Hello, everybody. This is Michael with Durfee Law Group here in Mesa, Arizona. And today I was going to talk with you about what's important in a trust. And in particular, what I wanted to educate you on is the protections that are available to beneficiaries if a trust is drafted properly. A lot of people might tell their estate planning attorneys, or they might put together a trust themselves that distributes their assets to beneficiaries upon the age of a beneficiary. So, for example, if Mr. Brown has passed away, and in Mr. Brown's trust, it says that the trustee of the trust should distribute the assets to his Mr. Brown's son Johnny and Mr. Brown's daughter Susie upon the age of 25. Then that trustee will distribute those assets to Johnny and Susie when they reach age 25 or afterward, no matter what's going on in Johnny and Susie's lives. So if Johnny is going through a divorce, or Johnny's going through a lawsuit, or Susie's in a bankruptcy, it doesn't matter. The trustee is obligated to distribute those assets because that's what the trust says, as long as Susie and Johnny have reached the age of 25 or older. So that is a mandatory distribution, and mandatory distributions and trusts are not good ideas because they essentially tie the hands of the trustee and don't allow the trustee to make decisions that would protect the assets of the beneficiaries from potential creditors. So, what is important in a trust, first of all, is that you provide the trustee with absolute discretion. Absolute discretion allows the trustee to be able to make decisions in the best interest of the beneficiaries. So, in that situation before, where Johnny and Susie might be in trouble, uh, the trustee can hold back those assets as opposed to being handcuffed to a mandatory distribution at age 25, in which the trustee would have to distribute those assets to Johnny and Susie. The trustee can instead, when given absolute discretion in the trust, hold back those assets until the bankruptcy runs its course, or until the divorce runs its course, or until the lawsuit is over and potential creditors are not there any longer. And at that point, the trustee can distribute the assets to the beneficiaries, Johnny and Susie, and they get the intended inheritance that Mr. Brown had put in the trust. Another thing to remember is that most trusts have what's called a spendthrift provision. And the spendthrift provision prevents people who might spend all of their inheritance in one day, especially if it's a sizable inheritance. That can be problematic. Or if the individual beneficiary has an addiction and is spending those assets on things that would damage their lives. Certainly, we don't want that as grantors, or in Mr. Brown's case, as a parent. So, the spendthrift provision is put in place to, again, allow the trustee to exercise caution in distributing assets to beneficiaries who may have gambling addiction or drug addiction or some other type of issue where they would take those assets and waste them. That kind of provision, the spendthrift provision, is disabled or does not have any teeth if the trust has mandatory distributions put into it. So if you look at your trust and it has a spendthrift provision in it, and then you have mandatory distributions in your trust, the spendthrift provision isn't really doing you any good. So just a few thoughts on trusts, a few things to look for in terms of protecting the assets of your beneficiaries. Just a reminder that revocable living trusts do not protect the assets of the grantors. So if you created a living trust and you have assets in that trust, those assets do not have asset protection because living trusts do not operate as an asset protection device for the grantor. They do, however, if drafted properly, operate as an asset protection device for the beneficiaries. Have a good day.